Presiding.
All right, good morning, everyone. Sorry I'm running a little late this morning. I don't have a list. I don't have any private counsel. All right, maybe I'm early.
I don't care. I can kick things off.
Yeah, no,
You want me to go? If you're ready, if you're fully ready, yeah.
I probably would be on board.
Raise your hand if you're ready.
I'm good enough to go, but
Yes. I'll let you know now, we don't have the females on site yet, so we'll just start plugging them in when we get them.
Judge, I do have, there are a couple of cases that are on the docket that shouldn't be. Because we already handled those motions. One of them has been brought over already. And when told that he would be going back, because we'd already heard he wanted to talk with me, I don't really have time to talk with him this morning. So
Okay.
I'm thinking let's go ahead and just bring him out and deal with it.
Okay.
He actually said he's good, so.
He is good?
Who's this?
So Hardy went back,
Dewan
Marion,
Dewan Hardy.
Hardy. We had a bond hearing on him back on the 9th. I think we'd done originally a notice of hearing for the 30th because we were a little close to the 9th.
And then we squeezed him in, right?
We squeezed him in and took care of it.
Okay. I looked at that yesterday and I was like, there's a notice, but then it's canceled, but I think we did it. And all right.
Marion said he'd still like to talk to you, so he's still, you can deal with that however.
Okay, well then we can go ahead and bring Marion out. That's the one where the state stipulated to the motion to compel. That's what the,
About the
Here,
jail
so-
video, I think.
right, we handled, I think, at either jury reviews or docket day. And then I've got a hearing on one that's out of custody.
Sorry, I'm just picking up my phone. I have to sign in to something. It's giving me the factor thing I gotta do.
Yes, sir.
Just before we move too far past him, on Mr. Marion, we got that order. We did send it to the jail. They sent us the videos yesterday, and I believe they were uploaded to the public defender's office yesterday before we left. I'm pretty sure.
It
know.
then gets something done with our crew before it shows up
Right.
on my computer. So
Yeah.
it's probably either on there now or will be later today. I don't know what they do with it, but they do something.
Everything has to be processed.
Yes, sir.
Ham, come on out, please, sir.
Come on out, Mr. Ham. Judge, this is Robert Ham, 2023 CF 673. Judge, it's a VOP arraignment. I'm going to enter denial on his behalf. At this point, we're not in position to be able to resolve it.
All right, what would you like to set it on?
Judge, I'm already thinking next week's going to wind up being busier than we expected. I don't know if anything's going to change between now and, I'm pushing on the stupid mic. Change between now and next week, so let's go ahead and set him for the later date in August.
Sorry, I'm trying to get my calendar open, but it keeps asking me for new information.
I called and asked them to contact you about this information. You wanted Ryan Williams' address. I don't know if they ever got in contact with you or not. I've never been able to get through. I've had to leave a message. Well, not yet.
All right, you want to do August 27th at 9 o'clock, Mr. Williams?
Yes, sir.
So that would be
fine.
without subpoenas.
Yes, sir, for now without.
All right, August 27th at 9 o'clock for Mr. Ham.
I'll come out and see you again, okay? Yeah.
This is Nathaniel Jones.
Give me just 1 second, Judge.
Okay.
Judge, can we set this one for next week? I'm gonna go out and talk with him again. I need to confirm something with him. We can get that one. I saw him yesterday.
Okay.
He's got a counteroffer he wants me to make. Let's set him for next week, and I'll make that counteroffer.
All right, August 6th at 9 o'clock.
Thank you. Okay.
9 o'clock. There we go.
Yeah, yeah. Okay. Next week, next Thursday.
Mr. Lee?
So this is William Lee?
Yes, sir, Judge, this is William Lee. I went out and talked to Mr. Lee again. At this point, we're not in position to resolve the case. Probably need to just go ahead and set it on a date for a contested hearing.
How soon would you like to do that? The 27th, was it?
Judge, that'll be fine.
All right, August 27th at 2 o'clock with subpoenas from Mr. William Lee, 23 CF 957.
Thank you, Judge. If anything changes where we can work it out, I'll come out and see you and let you know, okay? August 27th.
Thank you, sir. Have a good day.
Dakota Madden?
Thank you, Mr. Matt.
Judge, this case number is 2025 CF 1868, but I believe that there is a felony scheduled for arraignment this afternoon, 2026 CF, looks like 11:45.
Yes. And it looks like information was filed.
All right, Judge, what I'd like to do is enter denial on the VOP, plea of not guilty on the new charge. Go ahead and arraign him this morning.
Okay. Let's track down that information to give him a copy. It looks like in 26 CF 1145, it's possession of controlled substance, paraphernalia, and driving while license suspended. All right, denial's been entered as to the VOP. Plea of not guilty as to the new charge. We can take that off the 1 o'clock arraignment docket. You just want to put it on for pretrial?
Yes, sir.
Do you want next pretrial, which would be
Judge, I'm hoping
August
to be able to get them
26th?
both resolved fairly quickly, but I have warned him that we're not going to have labs back, and we're going to probably need labs back before we resolve this one. Let's go ahead and set it for them. I just don't know that I'm going to have an answer by then.
Okay. All right, we'll set it for pretrial August 26th, 9 a.m. If you do get it resolved earlier than that, we can probably bring it in. I may open up a date during my August civil trial weeks because they've gone away.
Yes, sir.
So I'll be in touch with you all about that if I do.
Yes, sir.
All right, August 26th.
All right, Mr. Madden. No, you will not come back.
Mars at Knox?
Where's it? Where's it?
Here we go. Judge, I haven't gotten a response back.
I'm sorry, who do we have today?
Oh, I'm sorry, this is Marzette Knox.
Knox.
It's Elijah Marzette Knox, 2020 CF 930. Judge, I've not gotten a response back to my original, or to the offer that I sent over to the state. We could set it for next week as well, just recall.
All right.
The weeks where we have pretrial conferences are always jammed up for us, time-wise.
Oh, I understand.
And so if I can get it resolved before then, or at least know where we're headed before then, I'd greatly prefer that. And the next VOP date, or next miscellaneous date is in the middle of that.
All right. So August 6th,
Yes, sir.
is that what you want? 9 o'clock?
Yes, sir. All right, so I'll reach out again, and we'll come out and let you know what happened, okay?
August 6th.
Yeah.
Yes, sir. All right, thanks.
Passenger?
Judge, this is Ryan Maxwell. You're going to come stand over on this side. This case is 25 CS 65. I believe he also has a new law violation set for arraignment this afternoon, but he's not represented by counsel on it. The judge didn't check off the appoint public defender box on the first appearance paperwork. I've
Okay.
spoken with him about it, and he would like to have us appointed. So if the court sees that and wants to appoint me on it, I'll go ahead and arraign him on that as well. Assuming that there's an information file. Okay, that's the charging document on that felony.
All right, I'll go ahead and appoint you in the 26 CF 1176. He's been handed information charging him with possession of a controlled substance.
Yes, sir. I'll enter denial on the violation of probation, plea of not guilty on the new law violation, 15 days for pre-arraignment motions and trial by jury, and ask that the two cases track together.
All right, do you want August 26th for a pretrial
Let me see what the charge is again.
possession?
Judge, we can do that. Again, I doubt I'm going to have a lab result back by then, but if I do, maybe we can get it resolved.
All right, August 26th, 9 o'clock.
Thank you, Judge. All right. Judge, I'm going to enter
Who's this?
denial. Oh, I'm sorry, this is Kendra Moore, 2025 CF 1589. Judge, I'm going to enter denial for him. The incident that led to the violation is being handled down in county court at this point. I don't think he's had a chance to talk with the misdemeanor attorney about it yet. And so I'm going to go ahead and just enter denial for him at this point and ask it be set off without subpoenas.
All right, looks like the underline is 26 MM 1726. It's trespass and theft of utility.
Yes, sir.
He's got court on August 4th. If they get it resolved and you want to bring it back here to resolve it August 6th, I'm fine with that. Do you want to just try to put it on that date or just put it off and then reset it if you can get it done?
Judge, let's do it that date without subpoenas then.
Okay.
And if we can get it resolved on that date, we will. I'll meet with Charles Hall. He's been trying to squeeze in some days off here and there. And so it's been hard to catch up with him, but he should be
fine.
back.
I just don't want it to wait for 3 weeks if y'all resolve it in county court next
Yes.
week. August 6th, 9 o'clock, no subpoenas.
That's on
And I've got,
That's on Moore.
I'm
Kendra Moore, 25 CF 1589.
just a little confused because of what's on the docket. The only thing I see on the docket, I see a felony case number, but the two charges are both misdemeanors. Is that correct?
He probably pled to probation to misdemeanors and
Okay.
it stays in this division, even though it's misdemeanors.
I just wanted to make sure that I'm not misreading what I'm seeing.
He's pled to a trespass.
Especially when he has a trespass as his violation as well, so.
All right, Judge, thank you.
All right, thank you.
All right.
More?
Yeah, that trespass was originally a burglary, which is why it was here.
Judge, let me pass Mr. Moore and talk with him in the conference room for a minute. Nothing has changed.
All right, Mr. Moore, we'll bring you back later this morning.
More, John?
Yes, sir.
More, John?
We're on 25 CF 605.
I was like, who? I'm guessing more, John, maybe.
Yeah, Morjon.
Oh.
This is Maury Snitsky.
Nitsky.
2022 CF 2244. Let me check my notes real quick.
That's one.
Judge, let's pass him. I just want to confirm something. My notes from meeting with him yesterday are a little unclear on what we're doing today. It is probably going to be a case where at some point, because it's an animal case, we're not getting an offer on it. It's probably going to be a situation where we do a straight-up plea to the court, but I need to confirm that that's what he's wanting to do. This is, I will, just for everybody's benefit, Mr. Nitsky entered a plea where he pled to one felony and then a series of consecutive misdemeanors. His, this violation is on one of the misdemeanors. He's got another misdemeanor after this. All the misdemeanors will run consecutive. I think the idea was to give him a total of probably 6 years or so on supervision. So his maximum exposure on this case is a year county jail with credit. I think the last offer that we sent over was some 9 months. But again, because it's an animal case, we're not getting a response on it. He does have some mitigation information that we'll provide to the court at the appropriate time. Basically, his mom passed away. It sounds like he's the one who found her and made the phone call to 911. And that situation put him at not his best self for a little while.
Okay. All right, what would you like to put it on then? So I'm just trying to track back. He pled before I was in the division, so I'm just trying to figure out this VOP that he looks like he got DOC on, but he hadn't started his probation on the other counts yet. It's just very strange.
Well, I think, and maybe I need to recheck as well, but my thinking was that he was already on, that this is one of the misdemeanor VOPs. And that will change things if it's the felony VOP. So I'll take another look at it as well.
I was just out on my first year of misdemeanor. I was doing what I was supposed to, just when my mom passed away. It's when the police officers died. I was already on my first year of misdemeanor.
Judge, if we can, let's set it for next Thursday and see if we can all confirm that. That will have a substantial impact on what we do.
Yeah, from the best I can read, back in August of '24, he got 24 months on the count one. Then once he was released from that, he was to start his consecutive years of probation for the 3 misdemeanors. So I think you're right in that his exposure is on misdemeanors only.
All right.
But I'd have to probably track through that a little bit more, but that's the way I see it.
Okay, all right, as long as we're in agreement. Judge, let's do, give me just 1 second. Judge, let's pass him. I'll get his signature on a straight-up plea, and if the court's of a mind to, we can perhaps resolve it. Go ahead and proceed to sentencing today.
Today, I don't know anything about you, Mr. Nitsky, other than what I just quickly read over the past minute or two. If you want to do a sentencing today, I can potentially look into that, but I don't really know enough. I'm not sure if the state wants to go forward on sentencing today. I mean,
What we could also do, Mr. Nitsky, is do the plea today and then set it for sentencing next Thursday.
I'm not trying to give you any sort of indication of what I'm doing, though, but when I read it, it's a violation for not reporting and absconding. So,
Yes, sir, but again, his offer has been 9 months, so the difference there is not that big.
okay. Mr. Sheik.
Yes, the state, if he does plead today, the state would just ask for the August 6th date to be able to review and prepare for it.
Okay.
All right, so Mr. Nitsky, I'll come back and talk to you. I'm going to explain what all happened today, and then we'll see if you want to go ahead and sign a plea offer for a straight-up plea today. If not, you don't have to, okay?
We'll see. Yeah, I gotta pray on this one.
Okay.
All right, so you just want to bring them back next week?
We can also do that. You want to just come back next week for a decision on it?
Yeah, if that's what it's gonna end up happening anyway, might as well just get it all taken care of at one time.
Yeah.
I'm ready to get this thing behind me and get on.
Well, I want to make sure you understand, Mr. Nitsky, just because your lawyer tells me something, he needs to provide me evidence of those things occurring potentially. So, if going forward on sentencing so fast, may not be in your best interest, because what you may hear from me is something to the effect of, I understand what you're telling me, but I don't have any evidence of that. So, I just want to make sure y'all are prepared. So let's go August 6th, and then if y'all want to enter a plea on that day, you can.
Yes, sir, and I'll talk with him and talk with my investigator, see, what it maybe would take to try to get the 911 call or something of that nature.
Understandable.
And it's not a 911 call. I was at the hospital when
All right,
I was in
all right, Mr. Nitsky, you can talk about it with your lawyer. I just don't want you to tell me something that's inconsistent with what he may want to argue next time.
Yeah, that's what I'm trying to correct though right now.
Okay.
I'll be in the court for it.
Well, he'll come talk to you outside of my presence, and that way y'all can talk about it.
That's right.
All right.
Got the females, first one out the door will be Ms. Jackson.
So was that 9 a.m.?
9 a.m., yes, thanks, sir.
Judge, this is Cassandra Jackson. Ms. Jackson pled to some lesser offenses. We've sent an email over to the state seeking an offer to confirm minimum guidelines. I think Mr. Seek actually handled it at the trial level with the assistance of Ms. Leone. But she's anxious to resolve the case. Does the state think that it can confirm what it's going to do in the case, what the offer would be, or whether it be minimum guidelines? And I'd still need to see a guideline score sheet rather than the one that I mark up from the original. When you just said it for the 6th as well.
Yeah, I not looked at this at all, and I don't even have the updated score sheet date. I don't think this was open until yesterday. What our score sheet says.
Let's just set it for 8-6. All right.
I'm just reading through the affidavit and it says something about her being a suspect in another crime.
Yes, sir.
All right, you want it for 8/6?
I'm, again, hoping to get it resolved. So far, there's not been any charges or any arrest on any other offenses.
All right, August 6th at 9 a.m. No subpoenas.
Thank you, Judge. All right, ma'am.
Ms. Melvin?
All right, Judge, I'm going to ask to pass her to the 6th without subpoenas. She sent over a counteroffer, and we're still in the process of negotiating.
Who is this?
Kyra Melvin. Just to remind you, this is the one I think you're offering, it's Josh,
Yes,
1129. She's coming back with 6, with the waiver that you were requesting.
Yeah, I'd definitely have to review that before I'd be.
All right, 8/6, 9 o'clock.
Thank you, Judge. All right, ma'am. Judge, this is Eunice Morjon, case number 2025-605. Judge, I talked with her again yesterday, and she made a new offer. Or a new request. I need to talk with the state about it. Set us, I guess, for 8/6 as well.
All right, 8/6, 9 o'clock.
All right, ma'am, so I'll get up with them. We don't really have time to do a lot today because of court, but I'll get up with them and we'll bring you back in next Thursday.
What was the last inmate that I have to use?
Judge, I have a motion to modify bond on Hojani Haigu, 2026-782, and I have probably butchered that last name.
Starts with an H, right?
Yes, sir. I told you the story about the four-letter name. It's not my finest hour. There's been a child safety plan done up by Department of Children and Families. I don't know if the court's able to see that. I have a copy for the court. I've given a copy to the state earlier today.
I haven't seen it because I don't think there's a judicial case, right?
I don't think so. I think it's still being handled prejudicially. But he's been in counseling through the Navy. He's in the Navy. And has complied with all the requirements. I had previously, in part of the motion, I referenced Christina Garcia with Families First Network, who I had spoken to. She advised that she was not opposed to a no violent contact order, but at the time they were not recommending he immediately move back into the family home. From the child safety plan, it sounds like actually they're contemplating he would move back into the home. I think previously there'd been a determination of video contact and or supervised contact of some sort, and then the state advised that he's been told by the attorney handling the case to be okay with supervised contact. But we're asking for more.
And the problem, this is the case where the arrest report is very hard to read. So I can't really read the allegations that were initially made.
Let me see if my copy's any better. Judge, I also have some intake notes from his mental health counselor. An email from Ms. Garcia that I can present.
Anything you want to present, Mr. Williams, I'll take a look at it. I just,
Yes, sir. I was hoping that the state would have contacted her. The motion was filed some time ago, and so that. Now, sir, some of these are clinic notes relating to your mental health. Do you want me to provide that?
Yes, sir.
Okay.
has the state seen them?
Those I'm not sure about.
Understand, sir, if I'm going to read it, the state has the opportunity to read it as well.
And let me go ahead and give them the email then from Ms. Garcia. And I did give them a copy of the child safety plan that was done up by Families First. No, but I have something to give you. They changed who's doing Veterans Court. Stuff this in here to give you. That's your contact.
All right, Mr. Williams, I saw the notes seem to be pretty lengthy. You just want to pass while he reads those, and then I'll take a look at them. Otherwise, we're all just kind of
Yeah, it's
waiting.
gonna be,
Why don't we take some other cases, and we'll call you back up, sir. Just, I don't have access to any of these documents. So I want to be sure I can read them. The state has to read them, and then we'll make a decision on what to go forward with. I still have the safety plan up here. I'll keep it until we're done.
Yes. Judge, I also have Johnny Howard Lee. This was set for a status conference. I believe the state was trying to get some information on the status of the victim.
Mr. Lee here?
I don't know that he, yeah, looks like he is.
Okay, Johnny Howard Lee. It's 26 CF 303. I've got it for the same status as to victim.
Okay. I almost blew that because I wasn't thinking fully.
Okay.
I've located the victim. She's in jail. She'll be here this afternoon.
Okay.
Is she on-
So what was the status? Just a finder?
Yes.
So it sounds like we've done that.
We have not found, we had not had any contact with her or anything else, but she's on this afternoon's docket.
Did you notice who represents her?
No.
I'll take a look at her.
Sturgeon.
Hang on, I can look real quick.
Amy? Amy Sturgeon?
Yeah. Is that you? Ah, your partner
We're gonna
represents.
have to figure out the conflict then. And
He's
see
here
who's
now?
keeping who.
It was on this morning's document.
We normally will keep, assuming that there's not a difference in number of.
Oh, I understand.
cases or
I'm
something
just-
like that, we'll normally keep the one we were appointed to first, but that's gonna have to get kicked up.
Well, I want to figure that out before.
Yes, sir.
Is there anything else we need to resolve today with Mr. Lee's case, though? Because I think the
No,
whole
Judge.
point of today was to find out where she was, and it sounds like the state has found her.
Yes, sir.
And she's a client of y'all's office. You'll have to make out a decision as to who you're going to keep, so.
Yes, sir.
And really, I think the public defender deserves credit because they technically found her before we did.
Well, no, that would be a matter of she found us.
All right, so he's already set for the August 24th pretrial. So,
Just leave him on.
Mr. Lee, you're set for August 24th. You're currently set for 1 o'clock, but the public defender's office is going to have to determine if they're going to keep your case or Ms. Sturgeon's case. In the event that you're appointed at the Regional Office of Conflict Counsel, you may be moved to 9 o'clock, so just stay in touch with right now, Mr. Williams. Okay. All right, August 24th, 1 o'clock.
Thank you, Judge. Okay. I've got, also got Kwamani Lee, 2025 CF 1154. Judge, give us a few minutes to get a signature on the offer. We'll bring him back in just a few minutes. Have a seat out there. I'll find you.
All right, Mr. Lee,
Thank
we'll
I'll
pass
get
you.
your signature on the offer. No, you can sit over in the corner there and I'll have him bring you back.
Who else do you have, Mr. Williams?
Darnell Marion, that's the other
I
motion
think,
here.
I think we called that already. That was the one, the jail video y'all.
Right,
Are in-
right. Was he out for that?
Wasn't, but.
He wasn't?
He wanted to
Okay.
go back, But he wanted to just talk to you about it.
Oh, okay, well,
so
just, I'll go out and
I figured-
talk with him, or I may tell you guys I'll just see him at the jail later. I'll let you know in a little bit. All right, Judge, then that's all that I have, until after I speak with the few folks I said I'd speak with.
All right. All right, Ms. Merrifield?
I just need to get a signature, so just a moment, Judge.
Okay.
I had Ms. Rivers lined up. I think Mr. Kleins was still waiting on something, right?
I have 2 inmates, but I should have somebody on soon.
Who's that? Oh, Betancourt?
Mr. Betancourt.
Are you ready on the other 2 inmates?
Not yet. I will be shortly. Yeah, I know.
All right, Mr. Betancourt, are you there? This video just turned on. I just need audio now.
Mr. Betancourt, if you can hear me, you need to turn on your audio and your video.
Looks like his video is on, but there's no feed. See, 'cause it says I can stop the video, so it's on, but obviously you can't hear him.
You want me to pass him? He's been in constant contact with my office. I can have him.
I'm not worried about it. We'll get it worked out, Mr. Kleins.
Okay.
Unlike most of us, Zoom is probably not his specialty these days. Although I don't know who's this phone. Let me check to see who this is. All right, who do we have on the phone by Zoom?
This is Jonathan Huck, sir.
And what are you here for?
I am here for the risk protection order, sir.
Risk protection order.
Yes.
I think it's been, let's see. I don't have it here. Let's see. All right, give me your name again, sir.
Jonathan Huck, sir.
Hello. This is Antonio Betancourt.
All right, hold on a second, Mr. Betancourt. We're going to handle something else really quickly, but I'm glad we can hear you. If you can get your video turned on or your camera turned on in some way.
Okay.
Trying to find Huck here. I just found it. I go digging through my emails for it. Let's see. 968. I just want to tell them when that's set for. All right, Mr. Huck, since you have a case that's pending, a criminal case, that's 26 CF 1325, I've continued your risk protection order hearing until November 3rd, since it comes from the same set of facts.
Yes, sir.
And you can certainly contact the sheriff's office, who's the petitioner in that risk protection order, if you want to discuss anything with them. Or if you want to try to get a sooner hearing, we can do that. But otherwise, it's set November 3rd at 9 o'clock via Zoom. It'd be the same Zoom address you're on right now.
Thank one, sir. Got it, sir. Thank you.
All right, thank you, Mr. Huck. Sorry to keep you waiting. I didn't realize that you were here for that.
Yes, sir.
All right, thank you. Have a good day.
Okay. Have a great day.
Thank you. All right, let's go back to Mr. Betancourt.
Your Honor, this is Antonio Betancourt. He's before the court. I have him in 23 CF 1116. Mr. Gates has him in 23 CF 820. I talked with Mr. Gates's office yesterday. He asked me to go ahead and cover his appearance today.
Hold on just a second. Mr. Betancourt, I'm going to mute you for a minute while we're talking, just because I'm getting some feedback from your line.
Okay.
All right, just unmute yourself when it's your turn to talk. Perfect, thank you. Go ahead, Mr. Kleins.
So I talked with Mr. Betancourt yesterday. The defense will stipulate that the court can make its competency finding based on the most recent evaluation of Mr. Betancourt, finding him competent.
All right, state agree with that or no?
Yes, Your Honor.
Okay, and I reviewed that yesterday. That was filed on June 30th by, let's see, Robin Bruton and Clarissa Kluke. And it's their opinion that Mr. Betancourt is competent to proceed and no longer meets the criteria for involuntary commitment. So based on the stipulation to make the decision based solely on that report, again, that the court reviewed yesterday, I will find that Mr. Betancourt is competent to proceed.
My assistant's already, if she's not already done it, she's gonna send the court an order today.
Okay.
And
I don't see one in my file, but go
it-
ahead.
I texted her while I was sitting at a stoplight on the way here, so it's
Careful.
coming. But if we can leave Mr. Betancourt's cases on the August 24th docket, I'm
That's
gonna,
Pretrial docket?
pre-trial, yes, sir.
Okay. All right, any issue with that from the state? All right, August 24th at 9 o'clock, Mr. Betancourt is your pretrial conference date. I'll sign the order once I receive it from Mr. Klein's office, and then we'll see you back on that date.
Yes, Your Honor.
Antonio, I'll give you a call, maybe not next week, but definitely before your court date, for sure.
Okay, yes, sir.
All right, thank you, Mr. Betancourt. Have a good day.
Yes, you too.
Turn it over to Miss Mary, if you would, I guess.
Ms. Merrifield, you ready?
I don't know if I've got her inmate right here. I know I have Mr. Nopes right here. Well, Scott, okay, you're up first. Come on.
Good morning, Ms. Merrifield.
Oh, the nasty wreck in Fort Walton.
That's what I heard.
Brady Merrifield on behalf of Ethan Scott in 26 CF 1243. He's here today. We'd originally scheduled this for a bond hearing. However, we have reached an agreement, Judge, if I may approach.
Yeah, that's fine.
4 sheets behind.
Okay.
And in 26 CF 1243, Mr. Scott is withdrawing his previously entered not guilty. I did submit that in writing just for the court's awareness. He is on the arraignment docket this afternoon.
Okay.
He is entering a no contest plea as charged to the terms that are listed. It will consist of, come closer, 36 months probation, $40 per month cost of supervision, standard court cost of $515, a substance abuse evaluation within 30 days, and to begin any recommended treatment. To start that within 60 days, he'll submit to random urinalysis and no firearms while on probation. He is a resident of Alabama. I have discussed this with Mr. Berry. We understand that there is a transfer fee, and we'll take care of that. It is a withhold.
Okay. Mr. Berry, any issue with the transfer?
Your Honor, he'll have to pay the transfer fee. Ms. Merrifield said 125. I think it went up to 150.
Okay, well, whatever it is.
Right. And one of her conditions was the substance abuse evaluation within 30 days. I don't know how quick Alabama can get around to get them in there.
Okay, as long as he's making a good faith effort, he's not going to be violated for that. But Mr. Scott, just make sure you stay in close contact with your probation officer between the transfer and our unfamiliarity with Alabama's services. We want to make sure you're getting that done quickly, especially based on the facts that I read. But we understand it may not be possible within those days, but as long as you're making an effort, that's all that matters. All right, Mr. Scott, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, can you state your full name and date of birth, please?
Ethan Tyler Scott. 01/28/05.
Okay, and Mr. Scott, you're here in 26 CF 1243, charged with shooting or discharging a firearm from a vehicle. So that's a second-degree felony, which it means it's punishable by up to 15 years in state prison. Do you understand that? All right. I have a plea and sentencing agreement between you and the state that would have you plea as charged, be a withhold of adjudication, 36 months probation, $40 cost of supervision per month, $515 court costs, substance abuse evaluation within 30 days, treatment to begin within 60, again, based on what we just talked about. Submit to random urinalysis, no firearms while on probation. You can transfer your probation to Alabama as long as Alabama accepts you and pay that required transfer fee. Do you understand that, Mr. Scott?
Yes, sir.
Have you had enough time to go over this agreement with your lawyer?
Yes, sir.
Did you understand and sign the agreement?
Yes, sir.
Are you satisfied with your lawyer's advice and representation in this case?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything other than the terms of the agreement that I just read to you? And do you understand by entering this plea, there won't be a trial of any kind? And do you understand that you'd be waiving any potential defenses that you may have? And do you understand that you're giving up your trial rights or waiving your trial rights, which are on page 2 of the agreement you signed? In fact, you initialed next to each one of them, right?
Yes, sir.
All right. And do you understand that if you're not a U.S. citizen, this could lead to your deportation or exclusion from the country?
Yes, sir.
All right. And based on that, what is your plea as charged to shooting or discharging a firearm from a vehicle?
No contest.
I'll accept your no contest plea as freely, voluntarily, and knowingly given. Place you on 36 months of probation, $40 per month, cost of supervision, $515 court costs. You're due a substance abuse evaluation within 30 days, and begin treatment within 60 days. Again, we'll note that you're transferring to Alabama and maybe a little bit slower, but as long as you're communicating with and showing a good faith basis that you're doing so, you won't be violated for that. Submit to random urinalysis. You're to possess or use no firearms while on probation. I don't have any objection to you transferring to Alabama, assuming Alabama accepts you, and you'll pay the required transfer fee, which may be up to $150. It's a withhold of adjudication like I previously announced. This is a guideline sentence, as he scored 22 points. I do need you to speak with probation, who's sitting there behind you, Mr. Scott. And then you have 30 days to appeal the judgment and sentence of the court. All right, thank you. Good luck.
Thank you.
Thank you, Judge. That's all I have.
Thank you, Ms. Merrifield.
Good morning, Judge. Here on behalf of Mr. Taquan Watson, 25 CF 0987. Judge, this was the case that we've had a problem finding the alleged victim in. It's my understanding that his probation officer got involved and was able to, make him
available.
Well, we couldn't ever get a date set. My office emailed on July 13th to every person involved in it, the probation office, the state's attorney, assistant state attorney, his staff, Amy Faulkner and Scott Klein's, and we never got a date. Never cleared a date. Now, having said that, I don't understand why that wasn't responded to. And I will tell you also, just being straight with the court, I'm included in that email address. I can't see that I ever received it on July 13th, so I don't know. Having said that, he would still like me to ask the court to give him a bond.
All right. Mr. Sheep.
The state would object for a couple reasons, Your Honor. Number one, we have found the ability to do it. We just need to set it. The state is not the one that's slowing anything up. My dates are available. Whenever we set it, we'll get it, and the probation officer will make sure that we pass the subpoenas on, Your Honor. Additionally, the state this last week, there are jail calls from the defendant that were sent to his girlfriend to call the person who was originally the guardian and tell the witness or the victim not to show up to court. And that happened from two different numbers that were both going to the victim's girlfriend number. That's the same number that was calling the victim's guardian, original guardian. And we have the jail calls, Your Honor, if you want them. We also have the Corporal Peters here to testify. She did the investigation into this. So, Your Honor.
Into the investigation into the phone calls?
Into the phone calls.
Mr. Nopes, have you heard of or heard the phone calls?
Judge, we got an email late yesterday afternoon, and I've not had an opportunity to listen to them.
Okay, well, what would you like to do based on that?
Judge,
Obviously, in making a determination on bond, and we always talk about danger to the community and flight risk issues, but is the third thing that we need to talk about now is, you know, the integrity of the judicial system, and that involves concerns about witness tampering for sure.
yes, sir. And Judge, assuming that, in fact, the jail calls can be proven to be him,
Okay.
and not somebody else using what, I mean, I don't know exactly what I'm dealing with. I know that the home wave account was Byron Williams's, where he supposedly, someone communicated finding.
Is he a co-defendant in this case?
No, not in this case, Your Honor. However,
Was involved in another case.
I remember the name from other cases, and I'm familiar with those. I just didn't think he was involved in this one.
however, Your Honor, the calls, there was one from the defendant's call where he says he's going to call from a different number. And then immediately after is the call to that exact same number from Mr. Williams's account. And then immediately after that phone call, he calls back from his original account number.
But let me just make sure we're all being clear then. So we can go forward with the bond hearing today if you'd like, Mr. Nopes, but you have the evidence. It was sent to you yesterday. They can play it today. And if I make a decision on it, then I'm not going to be inclined to come back on that same issue if there's not a change in circumstances. To come back and say, well, now that I've had a chance to listen to it and investigate it more thoroughly, now I'd like to have another hearing based on the same thing that we had on July 30th. So it's really up to you, Mr. Nopes, how you want to proceed. I don't mind putting it on for even next week for the same purpose, but I'm not, you know, and this is not my decision. This is how the rule works. I'm only supposed to hear a bond motion once unless there's a substantial change in circumstances, which.
What day and time next week?
I could do the 6th next week. August 6th, next week, next Thursday.
Next Thursday.
And I can put you in the afternoon if it makes it easier.
Judge, that would be fine. 2 o'clock, 1:30.
Whatever you, it'd be 9 or 2.
9 or 2? How about 2?
All right, let's do 2 o'clock.
Actually, Judge, let me strike that. I'm going to be here anyway with you.
In the morning?
Yeah.
All right, well, let's do 9 a.m. And you said your witness is here, anyway, Ms. Corporal Peters is over there as well?
What's that, Your Honor?
Your witness is here?
Yes, Your Honor.
Okay, I don't know, Mr. Nopes, if you want to try and speak with the witness in the meantime, but.
So yesterday, we did get dates and times that we could have the deposition. And so, we will, once we settle on a date and time, we will send the subpoena to the probation department. Probation officer, I think she meets with him on a regular basis, and she hands.
Weekly, I believe.
I'm sorry?
Weekly is from my understanding of what we talked about last time.
It seemed like it was every month, but I didn't want to say that, because I didn't know for sure, but yes.
That's what
Yes.
I seem to remember, I just don't.
Yes, Your Honor.
Wasn't sure about it, I just know it's typically weekly, given his situation.
Very good.
All right, then we'll see you back August 6th for purposes of the bond hearing, 9 o'clock.
Yes, sir.
Thank you, Your Honor.
And if there's anything as far as audio or anything like that y'all want me to listen to beforehand, I'm not requesting that or requiring that, but if if y'all want me to do that to save time on the 6th, I'll certainly do it. Just send it to my office.
Thank you, Judge.
Your Honor, can I call just my one out of custody real quick and get him out of here?
Sure, that's fine, if you don't mind.
Sean Armstrong? All right, this is Mr. Armstrong, present and approaching before the court in 25 CF 1368. Good morning.
Morning.
Your Honor,
Just a
Mr.
sec.
Armstrong has essentially been set for a status, more or less. I've spoken to Mr. Mall about his VOP. I have provided him both proof that he has enrolled and is making good progress in his batteries intervention program and continues to do so, and also the certificate of completion for the substance abuse evaluation. In speaking with Mr. Mall, he's not at this time requesting the state dismiss the VOP. However, my understanding is he completes the batteries intervention program and provides proof that that's been done. Mr. Mall would be inclined to request a dismissal at that point. So if Your Honor's okay with it, I would request we kick this out a couple cycles. My understanding is Mr. Armstrong should have his courses complete in about 9 weeks.
Okay. Mr. Mall?
We had a pretty extensive discussion both through email and phone call, so, but I think that that's the easiest way for us to do it at this point, rather than trying to go and set up for hearing and all that. I think if he's actually doing stuff, he's actually working, I'd rather keep it on that and have him do it that way.
All right, and I think the other issue is he on probation for another case as well?
He is, Your Honor. It is a consecutive 1129.
And I think with the situation, so is he not on probation on one of those? If it's consecutive, it hasn't started yet?
Correct.
Okay, and that's what, I got a bunch of correspondence from probation yesterday about how they want to proceed on that one or not. Seems to be the same allegations as to what's being done, but when did he go on probation?
It would have been about, 8 months now, something like that? Because it'd be 11/29, so it'd be October, so let's say July.
So he's still on
October. About
probation
9 months
only
ago.
on one of them?
Correct.
I think
Okay.
the next one's set to start in October.
Yes.
My recollection.
His
Okay.
term date would be October 2027.
All right. I just want to make sure, because when it came in, it was, I had some choices to make, and then I saw he was on for today's docket. I didn't want to make any choices until I heard everything.
Yes, Your Honor.
So obviously, if y'all are talking about potentially dismissing the VOP, then I don't want to have him violated in a case he hasn't even started his probation on yet.
Correct.
So, and Mr. Barron, I'm not sure, I know you were fighting off two people as we started this case. This is Mr. Armstrong. He's got consecutive 1129 probation, so he was violated on the first one. He's making steady progress on the reasons why he was violated, but he hasn't started his second year of probation on the other case yet. It's consecutive. And I received a bunch of things from y'all's office as to kind of what should we do. It sounds like they're talking about dismissing the VOP, so I don't want to violate him on the other case, which he hasn't even, number one, started yet, or two, he's making his progress.
It would be my understanding, we shouldn't have violated them on the second one because it hasn't started.
I don't, well, the things were sent to me, and so it was, are we gonna just dismiss the affidavit? But I haven't signed a warrant for it because of the situation that we've talked about.
If the court wants to dismiss the BOP and reinstate him, then we would reinstate to the first period of supervision,
Mm-hmm.
followed by the second period of supervision, and move on from there.
Are you, may I ask a question?
Go ahead.
Are
Go.
you okay with me reinstating him, and then if he doesn't complete it, then filing a VOP? Because that's what the issue was. I know in misdemeanor court, we used to drag them out and just let them bump along on the docket until they got everything completed, so that we didn't have to do the VOP.
I assume the conditions he has not completed are on both.
They said, yes, but he said that he'll be done in 9 weeks.
About that.
So that would still be before he's even into the second consecutive.
Yes,
Should-
we could take, if the court orders that we're not to violate him on whatever he's violated for right now until the end of the second term of supervision, the
Okay.
consecutive period of supervision, which is.
Well, it sounds like he's gonna be done with it before he even gets to that second year.
21/27 is when his overall term date is.
The only thing that would be outstanding once he completes this, I believe, would be his community service, which he would have the entire second term to do. It's 50 hours community service. Now, Mr. Armstrong has been working a steady job, so admittedly, he hasn't made too much progress on that, but he has at least started them. But that would be the only concern potentially at that point from anybody's perspective.
What's the state's position at this point on the one he's already?
Well, I think
Violation.
at this point, based on what probation's saying today, what Mr. Maddox and I had talked about yesterday, I think the state right now I think the better course of action at this point is I'm going to dismiss the VOP currently, let him be reinstated back onto probation. If he does not finish his batter's intervention program, which is obviously why I was dangling, just bumping him out, because then you'll just file a second VOP, but it'll just count as his first, is the way I'm going to play it going forward. Does that make sense?
When they turn around and submit another VOP within 10 days?
Right.
We don't want to do that.
Well, no, I just want to make sure he has.
Well, there's a pending violation in his 1367 case that was sent to me 2 days ago.
Which is the consecutive.
But he shouldn't even be on probation
Right.
yet for that.
Right.
What are the allegations in that, just so that I?
The same, it's the,
Exact
let's
same.
see. Being discharged from, thank you, from Bridgeway,
Okay, he's completed that, so I don't understand why that's still there, but okay.
BIP treatment,
Okay.
so it's all the same things.
All right, so I'll
And the
get with
50
this-
hours of community service. But I can't violate him if he's not even on that probation. That's why the current one is only for the 1368 case.
That's the only one I see on the document.
But I do have a violation affidavit for the 1367, which I don't think I can sign, since he's not actually on probation for that. So I'll typically when an affidavit's filed and I'm not gonna sign the warrant, y'all send me an order dismissing that VOP affidavit just to keep it clean.
I could do this, Your Honor, just for purposes of making sure everybody's on the same page and not causing any headaches or issues for anybody. I could call his probation officer, explain the circumstances, give her any paperwork that she is not seeing or doesn't have that I have from Mr. Armstrong, get her position on it, and then the state can make an appropriate decision whether they choose to leave this open or decide to dismiss it and reinstate him. Like you're saying, Your Honor, I don't want him to come down the road. He's completed everything. There's still a miscommunication, and he gets violated again as a result. So let's put him on the 6th. Let's get a firm position from everybody, and then whatever happens at that point happens. But at least the court and the state and I can all be on the same page with this.
Sounds like everyone's pretty close to there as it is, but
Yeah.
if you want to make sure of it, we can bring it back next week for the 6th. But again, if y'all agree to it, it sounds like since he's making steady progress and should be complete with everything before the first year's even up.
Should be.
And I don't have any issue with dismissing the VOP as well as the affidavit on the case that hasn't even started yet.
Yes, Your Honor.
All
Excellent.
right, all right, August 6th, 9 o'clock.
Understand all that? All right, sorry I drew that out, Your Honor. That's all I have for that one.
Just one quick one, so you can jump in line. Let me ask really quickly, do we have, let me get the name again.
Judge, I can call Mr. Wynn.
Hold on just a second. Do we have Ricardo Morris here? That's you, sir? I have his lawyer is on Zoom. Let me just go ahead and call that quickly so we can turn the Zoom off. Mr. Morris, come on up. All right, Mr. Cruz, are you there? Hand out of your pocket, sir. Oh,
Good morning, Your Honor. I'm covering for Attorney Tyrese Cruz, Natasha Del Rosario.
Del Rosario, okay. All right, and this is Ricardo Morris, 25 CF 2400. He's present in the courtroom here. What are y'all gonna do today?
Your Honor, there are a few immigration concerns that we are working on at the moment. We would just ask if we could reset this for an August docket date. We're trying to get this resolved, however.
Okay. What is he currently set for? He's currently set for August 24th at 9 o'clock.
Okay, perfect, Your Honor. At 9 a.m.? Thank you.
All right.
That's-
Mr. Morris, we'll see you back August 24th, 9 o'clock. All right, thank you, sir. All right.
Thank you.
Oh, hold on a second. Just come grab your paper.
No, he's good. I was just moving on.
Oh, I'm sorry. I thought he was holding out paperwork for him. All right, thank you, Mr. Morris.
Mr. Klein's.
Thank you. And I believe that's the last case we have on Zoom.
Thank you, Your Honor.
Have a good day.
You as well.
All right, Mr. Klein's.
Albert.
Your Honor, Mr. Byrd is signing a plea agreement to resolve his case. At this time, Mr. Byrd would be withdrawing his previously entered not guilty plea. On counts 1, 2, 4, 5, and 6, Mr. Byrd would enter a no contest plea. In exchange for the plea, the state will null pros count 3. The agreed upon disposition for Mr. Byrd on counts 1 and 2, he will be sentenced to 48 months in the Department of Corrections with credit for all time served. He would be assessed $615 in court costs, a $50 application fee, $100 cost of defense. There's a mandatory 1-year driver's license revocation on count 2. On counts 4, 5, and 6, these are misdemeanors. Mr. Byrd would be sentenced to time served. He's previously been adjudicated. May I approach with the plea agreement?
Yes, sir. Do we have a guideline for him?
Your Honor, Mr. Mall is going to have to redo the score sheet because count 3 is being dismissed. It should take him just under 48 months, but Mr. Byrd is willing to plead to the 48 months.
Okay, Mr. Mall?
And I could hand scratch it, or I could try.
I'm fine with that as long as everyone looks at it and agrees it's accurate once that's done.
Before coming off. 1.3 there.
$48 due to
648, okay.
$60.
That's right. Just like wait. 46.5. The guidelines are 46.5, Your Honor. There's no objection to that score sheet.
All right, thank you, Mr. Mall. All right, Mr. Byrd, if you could raise your right hand, do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, can you state your full name and date of birth?
Kyle Lee Bird, 9/14/94.
All right, Mr. Byrd, you're here as announced in 25 CF 1303, where you're currently charged with child neglect, fleeing to elude, and possession of methamphetamine. Each of our third-degree felonies punishable by up to 5 years each. Count 4 is possession of less than 20 grams of marijuana, first-degree misdemeanor punishable by up to a year in county jail. And then counts 5 and 6 are reckless driving and no valid driver's license. Isn't reckless driving a possible 90 days?
It is.
It's one of those specified traffic offenses. It's not going to change anything, but I like to be right about those things.
Yes.
So it's a 90-day possible on the reckless driving, and no valid driver's license is 60 days maximum. Do you understand your current charges, Mr. Byrd?
Yes, sir.
I've got a plea and sentencing agreement between you and the state that would call for you to plead no contest to counts 1, 2, 4, 5, and 6. The state would then dismiss or null pros count 3, which is the methamphetamine charge. On counts 1 and 2, which are the 2 remaining felonies, it'd be 48 months in the Department of Corrections. Credit for all time served, $615 court costs, $50 application fee, $100 cost of defense, and a mandatory 1-year driver's license revocation. Just so you understand, Mr. Byrd, I'm sure Mr. Kleins has told you this, that starts after you're released from your DOC sentence. And then in counts 4, 5, and 6, which are the 3 misdemeanors, it'd be time served. Clerk informs me court costs would be $648 due to the traffic. All right, do you understand all that, Mr. Byrd?
Yes, sir.
Is that the agreement you've made with the state?
Yes, sir.
Have you had enough time to go over the written agreement with your lawyer?
Yes, sir.
And are you satisfied with your lawyer's advice and representation?
Yes, sir.
And is that your signature here on the report, on the form?
Yes, sir.
All right, are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything other than the terms of the agreement that I've read to you?
No, sir.
You understand by entering this plea, there won't be a trial of any kind.
Yes, sir.
You understand you're giving up your trial rights, would start on page 1 and go on to page 2 of the agreement that you said you understood and signed.
Yes, sir.
And do you understand you're waiving all potential defenses that you may have?
Yes, sir.
And do you understand if you're not a U.S. citizen, this could lead to your deportation or exclusion from the United States?
Yes, sir.
All right, and I'm looking at a guideline sentence as previously announced of 46.5 months. No objection to that, Mr. Kleins?
No objection, I'm sorry.
You're fine. And Mr. Byrd, what is your plea to the child neglect, fleeing, attempting to elude, possession of less than 20 grams marijuana, reckless driving, and no valid driver's license? I'll accept your no contest plea as freely, voluntarily, knowingly given. State have an announcement on count 3.
Yes, the state will announce a no pros on count 3.
Count 3 has been null pros by the state. On counts 1 and 2, I'm going to sentence you to 48 months in the Department of Corrections. Give you credit for all time served, $648 in court costs. $50 application fee, $100 cost of defense, and a 1-year driver's license revocation. Counts 4, 5, and 6 will be time served. This is a guideline sentence. He scored 46.5 months, and the sentence is 48. Mr. Byrd, I'm going to need your fingerprints because this is an adjudication, so it's 2 felony convictions. And then you have 30 days to appeal the judgment and sentence of the court.
Your Honor, Mr. Byrd is from the Tampa area. He would request the court make a recommendation that he be housed specifically at Zephyr Hills CI if the department could make that happen so he could be closer to family. He's still got more than 2 years to serve on this sentence, even with gain time and all that. So he's going to request that the court recommend a facility down near Tampa so he can be housed near closer to family. I don't think he has any ties to this area.
I can certainly recommend that DOC place him near the Tampa area, but Mr. Byrd, I can't control that. All I can do is make the recommendation that you go there.
And I did explain that to him.
I'm sure you did, Mr. Kleins. I just don't have any control to tell DOC exactly where to place you because it depends on your classification and a number of other factors that they determine. All right, thank you.
Judge, count 1 and 2 are concurrent.
Count 1 and 2 are concurrent, yes.
Thank you. Yes. Thank you, Madam Clerk. Your Honor, this is Jessica Duffield. She is here on a VOP arraignment in 25 CF 1361. Just sign the date right here. She has reached an agreement with the state to resolve that particular case. She also has 26 MM 1672, which is referenced in the violation report. That's a resisting without. I talked with Ms. Flowers with the state attorney's office yesterday. She advised me this morning that she would be okay with a plea to time served on that particular case. Mr. Mall has no objection to that. If the court would be willing to accept the plea of no contest on that count, we can resolve everything today. She's being reinstated is essentially what's happening here on her BOP.
But she's not getting probation on the MM case,
She's
right?
not getting probation on the MM case. Her term date on the felony case is next August 6th or 7th.
It's my understanding now that the clerk's office is, if I take a misdemeanor plea, an MM plea, that it becomes my case.
Okay.
And so if it's going to be probation, that could
It's
lead
not-
to a violation, and that's why I ask. And
No,
I'm
that's
just-
good to know. Yes, it's time served, so Your Honor will not have to worry about it.
It just ends up skewing case numbers and caseloads, and if there's a VOP, I think it has to come to me, even though it's an M, it just
Understood.
trying to prevent any problems.
It is time served on that MM.
All right, thank you.
So the specific terms for Ms. Duffield in 25 CF 1361 would be that she would be sentenced to 30 days in the county jail. She's already served the full 30 days. She was booked on June 18th. That would be, the 30 days is credit for time served, followed by reinstatement to supervision, reimpose all prior terms of supervision. Specifically, there's $245 in restitution. That is the state's concern at this point. I have advised Ms. Duffield to take care of that as soon as she can. There'd be a $100 cost of prosecution, a $100 cost of defense on the felony case. In 26 MM 1672, she would plead no contest. There would be a $50 cost of defense. I believe court costs are $265. She would be assessed that. She would be adjudicated guilty on the 1672 case. They're both written on this VOP. I didn't have any misdemeanor plea agreements with me, so.
Okay with
May I
that.
approach?
Yes, sir.
Just for the record, Judge, I think the court cost on that misdemeanor is $270.
Okay.
Just to let her know.
Charge?
Resisting, it's non-traffic, it's not a battery, so 270 is typical. All right, Ms. Duffield, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right, can you state your full name and date of birth, please?
Jessica Nicole Duffield, 9/20/84.
All right, Ms. Duffield, you're here in 25 CF 1361 on a violation of probation. I have a plea and sentencing agreement that also includes 26 MM 1672, which is a misdemeanor case in county court. I'll accept that plea here as well. It's resisting without violence. Is a first-degree misdemeanor and punishable by up to a year in county jail. Do you understand that?
Yes, Your Honor.
Terms of the agreement are for you to admit your violation of probation. You'll be reinstated to supervision after a 30-day jail sentence with credit for time served. Reimpose all previous terms of your supervision, $100 cost of prosecution, and $100 cost of defense. One of those terms of supervision you previously were sentenced to, I believe, was $245, I think you said, Mr. Clones?
Yes, Your Honor.
In restitution, that needs to be paid. Make sure that gets paid. And then on 26 MM 1672, if you plead no contest, to be time served, $50 cost of defense, and $270 in court costs. There will be an adjudication on both the VOP and on the law violation. Do you understand that?
Yes, Your Honor.
Have you had enough time to go over this agreement with your lawyer?
Yes, Your Honor.
Do you understand the entirety of the agreement, including that it involves the MM case?
Yes, Your Honor.
All right, and are you satisfied with your lawyer's representation and services in this case?
Very much so, Your Honor.
Excuse me. Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, Your Honor.
Are you currently suffering from any mental health issues?
No, Your Honor.
Has anyone forced, pressured, or threatened you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the terms of the agreement I've read to you?
No, Your Honor.
And do you understand if you admit your violation, there won't be a hearing where the state would have to prove how you violated your probation?
Yes, Your Honor.
And do you understand if you enter a plea to the resisting charge in 26 MM 1672, there won't be a trial of any kind?
Yes, Your Honor.
And do you understand that you're giving up all of your trial rights?
Yes, Your Honor.
And do you understand that you're waiving all potential defenses in both cases?
Yes, Your Honor.
And do you understand if you're not a U.S. citizen, this could lead to your deportation?
Yes, Your Honor.
Okay, and what is your plea to the violation of probation? Are you admitting or denying?
I'm admitting, Your Honor.
All right, I'll accept your admission as freely, voluntarily, knowingly given. And what is your plea as to the resisting in 26 MM 1672?
No contest, Your Honor.
I'll accept your no contest plea in that case as freely, voluntarily, knowingly given. In the MM case, it's going to be time served, $50 cost of defense, $270 in court costs. I'll give you 90 days to either pay those costs or set up a payment plan. Since you're not on probation for those, I can't really roll that into your probation. As far as the felony case, 30 days county jail credit for time served, followed by that you'll be reinstated to your initial supervision, reimpose all prior terms of your supervision, $100 cost of prosecution, $100 cost of defense. Make sure you get that restitution paid.
Yes, Your Honor.
All right, Ms. Duffield, I don't think I need your fingerprints. There's initially a guilty on the VOP, and I don't think resisting is enhanceable. You do have 30 days to appeal the judgment and sentence to the court. Please talk to probation on your way out. Mr. Mall, you have the score sheet. Have you seen this, Mr. Klein?
I have, Your Honor. I have no objection to that.
Okay, and it shows 22.40 points.
And to clarify, Your Honor, it's 227 in restitution is what you.
227, okay.
227, so.
You said 245.
I did say 227.
Okay.
That's why I went.
I just want to make sure if my memory still works.
Mainly.
So, thank you, Mr. Klein.
I have nothing else. I do.
I just learned, Mr. Robbins is, he's come off and now he's dead.
Oh.
I may have just.
Clarence Robbins?
Ready to try.
I think I just signed the order yesterday, Mr. Klein. So.
Okay.
Although I was trying to keep up on orders while I was on vacation last week, this was not one I got to until then. Probably signed about 100 orders while I was on vacation.
Not really vacation at that point.
Never is.
Yes, Your Honor. Your Honor, Ms. Rivers just handed me a motion that she had filed for Mr. Robbins on a.
Mr. Robbins?
To.
No, no, just focus.
To reduce his currently set bond. Clearly, I don't know anything about what's going on. I would ask the court to leave Mr. Robbins' case on for next Thursday, if I can, so I can get up to speed and give him the best argument I can. I don't want to rush into this having no idea what's going on. I don't even know why he's in jail.
Okay. Well, it's an aggravated battery. I think he's got a
I see that.
$50,000 cash or professional bond, if I'm not wrong with that. All right. So we'll leave it on for August 6th at 9 a.m. for a bond hearing, if you'd like, Mr. Klein's. Just make sure to file a new notice so we know to keep it on that docket.
I'll get it noticed as soon as I get to my office this morning.
All right.
All right, I'll come talk to you probably Monday or Tuesday. All right.
And Ms.
Now I
Rivers,
saw
I had
that.
filed that motion to withdraw on the 21st, but again, I didn't get to it till
Understood.
yesterday.
No, I think. Now may I be excused?
Yes, Mr. Klein's.
Nobody's asked him out of custody. Landon's got also covered in
However, their arm wrestling match ends, I'll call whoever needs to go.
Nobody's standing there.
Okay.
You want to address Jacob Brown? He's in Santa Rosa County.
That's fine. Your Honor, Mr. Brown, Jacob Brown, 25 CF 1828, is being held in custody in Santa Rosa County. I have met with Mr. Brown and discussed the violation with him, the allegations with him. I've also discussed the violations with Ms. Leone. She needs some time to review them. I am optimistic that the VOP will either be dismissed or at least we'd be able to come to a resolution on the 27th based on my conversations with Mr. Brown's family into the circumstances. So, Your Honor, I would ask for I will enter denial today on Mr. Brown's behalf, and I would ask for 827 without subs.
All right, state any issue with that?
No objection for the state, Your Honor.
August 27th, 9 o'clock, without subpoenas.
Oh, I've just got a couple out, but I can call as soon as things are done.
He's got the one female, and we'll switch them out.
Okay. Oh, he needs to get some lunch. He's got
This is Jessica Carroll.
Your Honor, this is Ms. Carroll before the court in 23 CF 1531. Your Honor, her competency report did come back, no issues there, so she is competent to proceed at this time. And I don't have any reason to disagree with that.
Oh, this is Ms. Carroll, I'm sorry.
It is, Your Honor, 23
Okay.
CF 1531. I don't have any reason to disagree with that report at this time after speaking to Ms. Carroll further. What I'm doing now, Your Honor, is I've CC'd Mr. Mall on it, but I am having her evaluated both for mental health court and drug court as possible options here. So those evaluations will take place, Your Honor. I would ask for 827 without subs. At that point, I would have exhausted all possible, resolutions to this case. So if we're unable to come to any sort of agreement, we can set it for an evidentiary hearing after that point.
Was
Your
there
Honor.
a report?
For competency? No, Your Honor, it was internal.
Oh, okay. I
Yes,
understand.
it was not court ordered, it was internal. Again, I reviewed that report with Ms. Carroll.
Okay.
No issues from defense's perspective. She is competent to proceed at this time.
Okay. And what date did you want? Sorry, I'm
827 without, Your Honor, for the purposes of having her evaluated for both drug court and mental health court. And at that time, like I said, Your Honor, I don't think we'd have anything else that I could look into in terms of resolving her case. So if we're unable to resolve it, I'll set it for an evidentiary hearing after that
Okay.
date.
827 at 9 o'clock, no subpoenas.
Thank you, Your Honor.
Sorry, I was looking for the report and didn't catch that it was internal.
Your Honor, this is Mr. Chambers before the court in 16 CF 2769. Your Honor, Mr. Chambers had done a fairly lengthy prison sentence from the new law charge from Alabama that violated him in this case. Should have been about 4 years, Department of Corrections. So I'm working to track down that paperwork and provide it to the state and see if we can work something out in relation to that. I believe he's around 15 years supervision in Alabama. 16. He's on 16 years of supervision in Alabama, Your Honor. So I think we'll be able to work it out. I'd ask for August 6th to try and get that paperwork and provide it to the state and see if we can do anything without subpoenas. Enter a denial at this time.
August 26th, 9 a.m.
Or I'm sorry.
I'm sorry, you wanted the
6th.
6th, August 6th,
Yep.
9 a.m.
Thanks.
All right, thank you, Mr. Chambers.
Mr. Clinton. This is Stephen Clance.
Yes, Your Honor. This is Steve Clance before the court. Stephen Clance before the court in 24 CF 2514. Your Honor, I'd ask for August 6th without. I did send an email to the state and discussed it briefly with Mr. Sheik this morning. He's going to review and see if we can work it out on August 6th.
All right, August 6th, 9 o'clock, no subpoenas.
Curtis.
Hey, Mr. Curtis. I'm doing all right. This is Patrick Curtis, Your Honor, before the court, 26 CF 22. Your Honor, we got the additional testing back from Dr. Zeman. I have provided that report to Ms. Leone. She needs some time to review that. What I would propose at this time, Your Honor, is set it on 8/27. That'll be after Ms. Leone returns so that we can have a competency hearing. My understanding is she intends to stipulate to the report, although I don't have 100% confirmation on that. She needs some more time to review it. But I'd propose setting this for 8/27. Or I guess he's got pretrial conference on 8/26, but that's probably not the best date to do the competency hearing. So I'd propose setting it for a competency hearing on 8/27. Ms. Leone had informed me that she does not intend at this time to seek a second report. So I do believe one way or the other, we'll be able to have that hearing, determine what's best, just so the court is aware and I can provide a copy of the report just so it can track along as I'm kind of speaking about it, my approach.
Sure. Is this going to be filed?
It will be at the time of
Okay.
the hearing if it's stipulated to. The circumstances are, Mr. Curtis does have an intellectual disability that significantly impacts his ability to, assist me in his case and rationally understand everything that's going on. Dr. Zeman is fairly certain that outpatient treatment would be appropriate. It's just how we go about that in the coming days. I'll talk to Ms. Leone about it and see if we can come to some sort of understanding, but if not, I'd imagine it'll be some sort of conditional release plan to try and get him outpatient treatment, potentially an evaluation from the agency for persons with disabilities, although at this time I don't think so. It's not recommended in the report. I'm going to talk to Dr. Zeman a little bit further about it, but one way or another, we'll hash it out on 8/27, and then if he's put on conditional release, obviously we'll get him started with that. If he's not, then we will act in accordance with the court's decision at that time.
August 27th at 9 a.m. for the competency evaluation, but he does have, as you stated, pretrial on the 26th at 9.
Yeah, and I don't think anything further would need to be done on that day. Do you want to just go ahead and knock that one off and put him on the 27th, just so he's not coming?
Well, 'cause I don't want to make sure he's got a pretrial date, so
Sure.
I mean, you
Okay.
can certainly move to continue it if necessary at that point, but he always has to have a pretrial conference date. Otherwise, he may fall through the cracks, so that competency evaluation or hearing gets canceled for any reason.
Yes, sir, Your Honor.
All right, thank you.
All right. Your Honor, this is Mr. Dodd before the court in 21 CF 2383. I had spoken to Mr. Berry about Mr. Dodd's case. Mr. Berry is okay with him being reinstated. I've talked to the state some about that, Your Honor. We're not quite there yet. Mr. Sheik still needs to review it, and I believe he would still need to contact the victims in this case to do anything with it. At this time, Your Honor, we'll enter denial. And do you think you'd be able to do that by August 6th, or do you want me to just go ahead and set it out till the 27th, Mr. Sheik?
I think 27th would be better.
Okay, I'll
Then
set
we
it out
can-
to the 27th without subpoenas, Your Honor, for hopeful resolution at that time.
All right, August 27th, 9 o'clock, no subpoenas.
Your Honor,
It's
this
reviewing
was
it,
a
okay.
GPS issue.
I'm just reading it,
And,
yeah.
Right, and he did complete a year of community control. So he did it 30-some-odd months in prison, came out on a year of community control, GPS, and then right at the end, the GPS issue got it
Yes.
of the year. He still has 3 years probation.
Okay.
He was effectively homeless, right? Living in a camper.
When he became homeless is when Mr. Dodd started having the GPS issues for about 45 days, maybe. And Mr. Dodd knows I work with him. I took him chargers and we tried everything. But
I seem to, I'm not sure that's in the affidavit, but I think it was in the report that I read.
Yes, Your Honor.
Yeah, I recall it now. All right, August 27th, 9 o'clock.
Yes.
Your Honor, we withdrew from this case due to conflict.
Okay.
Let me know if you don't have the order. I'll make sure we get it to you.
I do not, I see a motion was filed, but I don't have an order.
I'll make sure you get it, Your Honor. Mr. Duckett, I have to withdraw. Okay, go ahead. Just so the court is aware, Your Honor, Mr. Duckett is trying to resolve his case today. Unfortunately, I can't do that for him, as I just explained to him. I explained to him that he could have conflict counsel appointed, of course. He does want to see what the state's offer is. At least, Your Honor, I'll leave it to the court to handle that situation.
Okay. Well, I'd rather you have an attorney here representing you. So what I'll do is I'll put you on for next week.
So can I see what the deal is, Your Honor?
I'm not letting you take it unless we're going to have to go through a Ferretta hearing to see if you can represent yourself.
Judge, and just so the court is aware, I don't even have an offer at this point because I had just gotten it and it's only been open for a couple days.
Okay. And I'm looking at its positive drug tests and absconding.
To give you a ballpark. So unless I'm misreading, it looks like he had absconded for about 60 days. Is that what you guys have? Or-
I don't have anything.
Oh, okay.
I'm looking through it now. Let's see.
I mean, that's the way I'm reading the first paragraph on the violation.
Yeah, it looks like at least 60 days. Plus, there had been an alternative sanction that was done to include jail time to be served in Santa Rosa County for his benefit as opposed to coming here, and that didn't seem to work out either.
Prior score sheet, Your Honor, showing only misdemeanors as well, so that's something for Mr. Duckett's consideration. This would, I believe, be his first felony conviction.
Well, the state hasn't given him an offer. His options are to plead Office of Conflict Counsel representing you.
Yes, sir, Your Honor.
How would I plead straight up without a lawyer, sir?
I'll be honest with you, Mr. Duckett, without knowing more about your case, I wouldn't feel comfortable sentencing you anyway. I understand you want to get out. I have concerns about what you're going to do if you get out, since the violations are alleged to have been repeated use of methamphetamine, as well as absconding from obstruction. So I don't think it would be in your best interest to plead without a lawyer at this point.
The first drug test?
Hold on, don't.
We're not going to talk about the facts of your case unless you have a lawyer and want to have a hearing.
Yes, sir.
So I want to put you on August 6th. Mr. Maddox, if you can send me that order, but I'm appointing Mr. Kleins to your case. He'll come out and talk to you. But you've been given a lot of opportunities here, Mr. Duckett. I suggest that you take up the one involving a lawyer. August 6th, 9 o'clock.
I'll let Mr. Kleins know, and I'll get you that order, Your Honor.
Yes, sir, thank you.
I've also read the statements that were written in your affidavit. As far as what you said to probation, I've got concerns.
James Ferguson.
All right, Mr. Ferguson.
I believe the state has an announcement.
Your Honor, based on this being based on the new law violation, and that new law violation was null prost.
Okay.
The state is requesting the court to dismiss the VOP, Your Honor.
The misdemeanor battery case, Your Honor, I might be able to.
So when I click on his name, it usually brings up all of his other cases. However, it's listing his name as his business name, which is, in civil cases, you type in the business name as opposed to the last name and first name. So I'm just trying to find his other situation.
The misdemeanor case, Your Honor, is 26 MM 917.
That sounds right.
That was closed, it's dismissed. All right, that was dismissed back on July 7th. And that was the sole reason for this VOP, is that right?
Yes, Your Honor, that's correct.
All right, VOP will be dismissed, Mr. Ferguson.
Okay, and just for Mr. Ferguson's benefit, his scheduled termination date is April 25th of 2027, so sir, you'll still have to report to probation and finish it out, okay?
All right, Mr. Barry, do you need to speak with him just to, all right, Mr. Ferguson, if you could talk to probation before you leave. Thank you. VOP was dismissed.
If I could have just a brief moment, Your Honor.
Sure.
Okay, good. Yes, sir. Okay, do you want to address anything with the judge?
No, sir.
Are you sure?
Yes, sir.
Okay. Your Honor, thank you for that. This is Mr. Ford before the court in 26 CF 464 and 22 CF 3188. Spoke to Mr. Mall fairly extensively about this case the other day. There was a score sheet issue which we've resolved, so that's resolved. With that, Mr. Ford is now likely a good candidate for drug court, so we're going to get him evaluated for drug court and see what drug court comes back with, Your Honor. He's also gotten into Phoenix House, so I'll talk to Mr. Mall about that as well. One way or another, I'm optimistic of a resolution. I guess he's set for the 26th. We could set the VOP for the 27th without subs. If we don't resolve it at that time and have an answer from drug court and all Mr. Ford's options have been presented to him, at that point, defense would be prepared to either enter a plea or set it for an evidentiary hearing at the next available date. Yes, sir. Mr. Ford did speak to me at the jail. He had indicated he wanted to address some things with the court. However, I've talked to him just now, and he no longer has those concerns.
All right, Mr. Ford, anything you want to bring to my attention?
No, sir. Thank
All right. We'll set him for August 26th at 9 o'clock. That's his pretrial on the new
Thank
law
you.
violation.
Yes, sir.
Do we want to set it for the 27th?
As an evidentiary, no, but we would set it at that point, like I said.
I think we could just address it on the 26th then,
Yes, that's
if
fine.
it's not going to be a VOP hearing.
Yes.
All right. Put everything on August 26th, 9 o'clock.
Just to make sure, have you already talked to drug court,
I emailed him.
Tiffany?
I'm almost positive I did. If I did not, I'll make sure I emailed him today.
Okay, I just didn't know if I needed to do it or if you had already done it.
I'm pretty
It's
sure.
usually better if you do it than
I
I
will
do
make
it.
sure that I did.
Thank y'all.
Yes, sir.
All right, thank you, Mr. Ford.
Fuentes.
Good morning, Judge.
Morning.
All right, this is Pedro Fuentes, 25 CF 1729. Your Honor, probation's recommendation in this case is reinstatement, but their recommendation is contingent upon him getting into some sort of program based on Chrome not really working out too well. That being said, there were some circumstances there that probation felt warranted their recommendation of trying to reinstate him and getting him into a different program. He's been trying to get into the Jada House, however, he's telling me that who he spoke to needs me to initiate the application process, which is fine. I can do that, Your Honor, so I will do that. Try and get him into Jada House. We also sent him applications for Phoenix House and for Keaton House to send those off, Your Honor. So I would ask for a continuance in this case. I would ask for August 27th without subs, and I'll be able to advise the court on the circumstances then.
August 27th, 9 o'clock, no subpoenas.
Thank you, Your Honor.
Guys.
Your Honor, we're going to have a resolution in this case. Mr. Mull, do you need a couple more minutes to get that score sheet together?
Which one is this?
Mr. Geis? Judge, it is going to be a downward departure based on negotiated plea. is my understanding. This agreed-upon sentence will be 18 months, Department of Corrections with credit for all time served, Your Honor. $100 VOP fee, $150 cost defense, cost to judgment, adjudication of guilt, probation will be revoked and terminated. He will admit to the violations that are pending.
What does he score?
He scores 21, his LPS is 21, his total points are 56.
Okay.
So it's a minor downward departure. All I need to do is print it out, I don't need to edit it or anything?
Nope, just need to
Okay.
print out. Yeah. All right, good point. I'll date it for you. May I approach, Your Honor?
Yes, sir. Thank you.
I'll just speak clearly, yes, Your Honor.
Need a state signature on there, too.
Oh, all right.
It's all right.
Try again. May I approach?
Yes.
No objection to that score sheet.
All right, Mr. Geis, can you raise your right hand? Do you swear or affirm the testimony about to give is the truth, the whole truth, and nothing but the truth?
I do, yes, sir.
All right, can you state your full name and date of birth, please?
Austin Gregory Geis, October 31st, 1996.
All right, and Mr. Geis, you're here in 24 CF 2576, where you're charged with violation of probation. You understand that?
Yes, sir.
I have a plea and sentencing agreement between you and the state that I would call for you to admit your violation of probation. What happened with those new cases, Mr. Maddox?
I believe no, you said they were going to do 90 days, credit for time served. I think they're still pending, but I believe there's been a resolution reached in principle in that case for 90 days, credit for time served, which he'll have in.
It looks like he's set for next Monday. All right. Mr. Geis, did you have enough time to go over this agreement with your lawyer?
Yes, sir.
Did you understand and sign it?
Yes, sir.
Are you satisfied with your lawyer's representation and advice in this case?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances? Are you currently suffering from any mental health issues?
Yes, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything other than the terms of the agreement?
No, sir.
And those terms are 18 months DOC, credit for time served, $100 VOP fee, $150 cost of defense. Your costs will go to judgment, adjudication of guilt, revoke, and terminate your probation, right?
Yes, sir.
Okay. You understand that if you admit your violation of probation, there won't be a hearing where the state would have to prove how you violated?
Yes, sir.
All right. And do you understand you're waiving any potential defenses that you may have?
Yes, sir.
All right. And what is your plea to the violation of probation, Mr. Geis? All right. I'll accept your admission as freely, voluntarily, knowingly given. Adjudicate you guilty, sentence you to 18 months in the Department of Corrections with credit for time served. That is a downward departure, as he scored 21 months as the lowest permissible. Reason for that, Mr. Mall?
Fair.
Uncoerced plea bargain?
Yes, Your Honor.
Okay. $100 VOP fee, $150 cost of defense. All costs and monetary will go to judgment. Revoke and terminate your probation. I don't think I'll need his fingerprints. He was previously adjudicated, right?
That's correct, Your Honor.
Okay.
I don't have them in the.
All right, well, they seem to be missing, so they're going to take your fingerprints, Mr. Geis, and then you have 30 days to appeal the judgment and sentence. Good luck to you, sir.
Yes, sir. Thank you.
that's all I have. Madam Clerk, correct me if I'm wrong.
I believe that's it.
All right, Ms. Rivers?
Your Honor, one of the people that I have out of custody is Mark Santos,
Mr. Santos?
25 CF 2257. Your Honor, we filed a motion asking to modify the pretrial release conditions. He was originally given a bond modification that included a bond reduction and a condition that he had to wear an ankle monitor. And one of the reasons being was at the time he was going to be he was homeless and was going to be staying in Alabama.
Okay.
Near family or with family. Since that time has occurred, though, Your Honor, he has gotten a place here back in Okaloosa County, Florida, and has been staying in Okaloosa County for how long have you been back? 2 months.
Is pretrial aware of that?
Yes, he continues to report in, Your Honor. And he was asking the court that since he is back in Okaloosa County, if the court would consider taking him off the ankle monitor and leave all other conditions in place.
All right, state's position?
I have not heard anything as far as from the victim why he would have been on a GPS monitor in the first place. I've looked at the notes. I don't see. I think it just strictly was because he was not living here local. The victim in this case has pretty much been more concerned about the defendant's mental health more than anything else. He did oppose a bond in the first place, but that's already a moot point at this point. So. No trespassing at his house, all that got put in on the original one, so I assume that if the court is going to take the ankle monitor off, that he knows he still can't go around him, he still can't have contact with him, third-party contact or anything else, and, still required to live under the law for the rest of us throughout the state until he gets this case resolved.
When was the GPS monitor put on?
You remember when it was that you? He says February, Your Honor.
Okay.
I didn't hear what Madam the Visitor said, but does he have a location that he's living here? He has a physical address?
Yes.
He's not
Yes.
living on the streets, right?
Correct.
Okay.
All right, I'm just reviewing the previous reports by pretrial, and it looks like they had recommended the GPS monitor, seemingly primarily because of his living in Alabama, and he was supposed to stay with someone else, and that kind of didn't work out. and concerns about his lack of a permanent residence. Now that he's complying with pretrial services and and they have his address, so what I'll do is I'll grant the removal of the GPS monitor. I don't see any prior failures to appear or any other concerns since he'll be living now in the jurisdiction of the court. But it's dependent on the fact that he continues to reside at the address provided to pretrial services. If there's to be a change, as long as it's in Okaloosa County, I'm okay with it. But you have to make sure Mr. Santos to provide that information to pretrial services and comply with all the previously given conditions. And Ms. Rivers, if you want to give me an order just to make sure that it's clear on the court record.
Yes, Your Honor.
Thank you. Just to make sure, Mr. Santos, no contact with the alleged victim in the case, no direct contact, don't go within 500 feet of his residence, don't go within 100 feet of his vehicle. You've already been told that, you know that, I'm just kind of making sure it's on the record again.
Next court date is in August.
I would guess it's August 24th.
Yes, Your Honor.
August 24th, 1 o'clock is your next court date.
Okay.
Thank you. Thank you, Mr. Santos. You're free to go.
Thank you, sir.
I'm ready.
Spinning.
Your Honor, this is Sylvia Finney, 25 CF 1166, and speaking with the state, I'm going to ask to put this on for August 6th.
All right, with or without?
Without.
Without subpoenas, all right, August 26th, I'm sorry, August 6th, 9 o'clock.
Just to be clear, don't owe you anything or you just bump it in. Okay, just making sure. Yeah, okay. I just want to make sure I didn't have anything I owed you.
Yes. Your Honor, this is, let's flip
Sturgeon?
over to her. This is Amy Sturgeon. She's before the court on 25 CF 1510 on arraignment for violation of probation. We're going to enter a denial at this time and ask if we can put it a month out.
Right. I guess my only concern is y'all are gonna have to make a decision on her or Mr. Lee, right?
And we don't have the authority to do
Oh, I
that.
understand, I'm just making sure, do we wanna bring that back earlier, or just to make sure?
We could bring it back for August 6th to see if Mr. Russell's made a decision by then.
I just wanna make sure that she has a lawyer who's gonna be able to represent her. All right, let's put it on August 6th, just for status of conflict. Nine o'clock, no subpoenas.
Your Honor, this is Javier Sabio, 22 CF 664. We're going to go ahead and set it for contested hearing.
What day would you like that?
End of August? I believe is your next.
August
one.
20s.
August 6th would be too soon.
Soon. So that's the 27th. All right, let's set it for August 27th at 2 o'clock with subpoenas.
Yes, Your Honor.
Thank you.
Mr. Wright.
Your Honor, this is Gary Wright. Before the court on 25 CF 1812. We're going to enter a denial at this time. We're going to ask to put this on August 6th to see if the state has an offer.
All right, August 6th, 9 o'clock, no subpoenas. August 6th, 9 o'clock. Thank you.
Your Honor, I also have listed on this morning's docket James Rolandi, 24 CF 137 for status. I'm also covering for Mr. Williams regarding Edith Rolandi. And that's going to be 24 CF 162. Your Honor, Mr. Williams had gotten approval from the JAC to get the transcripts of the trial. So at this point, we are waiting on that. We would just ask for another status date.
Okay, let me see. And I signed that for her case back on the 21st. You need me to sign an order for your case? Does that matter? Okay, I just want to make sure if you do, I can get that done. Have they given Mr. Williams any idea on when that might be done?
No, sir.
You want to do August 27th then for both at 9 a.m. for status on the
Yes, sir.
transcripts?
Your Honor, there was also another, there was another case that we needed to address. He is an inmate, but they did not bring him over. As Gregory Spears, 12 CF 1016, 12 CF 1224. Based on my discussions with the state, I believe they're going to go ahead and set it for contested.
You said this was Spears? Yes, Your Honor, the state would request to set this one with a contested hearing.
Why didn't they bring him over? What day would you like it set?
27 is fine, Your Honor.
August 27th, 2 o'clock with subpoenas.
Your Honor. Todd Taylor? Which one?
Wayne Moore, he's in the hospital.
Yes.
Him under-
Yes, and that had gotten changed to J, but I can address that as well. Dwayne Moore, 13 CF 2577. I believe this was a status as well, Your Honor, regarding his treatment.
Yes. Sorry, I'm just trying to find my notes. All right, as far as Dwayne Moore, I did read his report from Appalachia. Recommended that he remain in that conditional release at that time.
Yes, Your Honor.
All right. How far out do you want to set it for the next?
2 months?
Let's see. Why don't we do September 24th at 9 a.m.? Oh, nope, that's wrong. That's my trial week then. October 1st, 9 a.m.
Yes, Your Honor. Your next one, I would.
September's just a weird month because September 1st is a Tuesday, so it just kind of sets off all the weeks. All right. October 1st for Mr. Moore on status.
Your
His
Honor,
residential
next one is
program.
Todd Taylor, 24 CF 576. Motion to correct had been filed.
Is it just the issue about it was checked that he pled?
Correct, Your Honor.
Okay. Has the state had a chance to review the 3800 motion?
This would-
It has, Your Honor.
I believe the issue was just, it was a trial and was it the order of probation? The judgment and sentence, I think, was accurate, but the order of probation was wrong. Just said that he pled, not that he went to trial.
Correct.
Yes, Your Honor. Yeah, and I have notes here to no objection to the motion by the state.
All right. So I'm going to grant the 3800 motion for the sole purposes. I want to make sure I get it right now here. It was the probation order, right?
Let's see, the order of sex offender probation says that he entered a plea of no contest to count 3.
All
And he
right,
was
so
found guilty.
we just need a new order of sex offender probation that checks been found guilty by jury verdict instead of entered a plea.
Under the next one is Ronnie Watts, 26 CF 183. Previously, when we were in court, the state announced a null cross, and Ms. Watts was present. She was present this morning as well, but I went on ahead and excused her. The court asked for this day as a status day to see if the state had filed a written dismissal.
I think it had been,
and they
yeah.
have.
All right, so I'll be taken off the docket. All right, Mr. Williams?
Yes, sir. Mr., and sir, I'm sorry, I am just continually going to butcher your name.
I haven't seen him in a while.
I
Hughie?
spoke to him earlier, and I told him that I talked with the state and that we were going to pass it until next week, and asked to see if he could come back, and he may have misunderstood me.
He may have to do? That's not an answer to the question I just posed. What do you feel he's doing that's not in your best interest?
Other day, like, he called my dad the day before yesterday. Then yesterday, he told me he can't call him. It's against policy, but he did it the day before yesterday. And you're not supposed to do it, right? But you did it.
He asked me to call his dad when I was meeting with him at the jail.
Mm-hmm.
And I called his dad. His dad and I spoke. I had his dad on speaker so that he could hear his dad. And his dad has my personal cell number. I have his dad's personal cell number. Over the years that I've been representing Zaki, he and I have talked many times. Zaki asked me to call his dad again last night. During the course of the previous conversation, his dad and Zaki began having a conversation. And I declined to do that again because I felt like that was going to violate the jail's rules regarding telephone communications that aren't subject to their monitoring system. And so I told him that I wouldn't do that. He's upset with me about that. He asked me to call his dad again while we were in the interview room. I told him that I was not going to do it under that circumstance. I would call his dad after I left court. And I told him that I had left paperwork for his dad, that his dad apparently had not had the chance to pick up, and that I've been in communication with his dad. But he did ask me last night what his dad had said. I also declined to answer that. I told him I felt like he needed to talk with his dad, not have me act as a go-between between the two of them. Although his dad did tell me what he thought Zaki should do.
All right, so what's the issue, Mr. Moore?
I just don't feel like he's helping me in my case at all.
Tell me specifically what you think he's not doing for you that you've asked him to do or that he's doing that you think is against your interests. I can't just take your word for it. You have to tell me specifics.
Not trying to help, like even going over my points, because my points is not right on my score sheet.
Actually, Judge, that's not true. I did go over his points. That was part of the packet that I had set aside for his dad to pick up, and I gave him a copy of it last night. I went over his score sheet. I wrote down each of the charges on his prior record and what case number I found those charges under. I in fact found.
What's the score sheet say now? I'm looking from when he pled back in May. I'm sorry, not May. April.
Well, that's what I have is the score sheet from May, and what I do is I take that score sheet, I go out to the jail and see them, and I add the additional 6 or 12 points, whatever's appropriate, so they have an idea of what they've got. I actually don't have a formal score sheet.
I don't need to see. I'm looking at the last one.
And so.
So before he scored 62.20 points, it would add 6 for a non-new law violation.
68.2, 68.2 minus 28 is 40.2 times 0.75 is 30.15, and I gave him a copy of that as well. And I've previously gone over it with him.
Okay, what specifically are you concerned about, Mr. Moore?
Oh, because my dad was telling me other reasons about my points.
Well, your dad's not here, and you're an adult, right?
That, but him and my dad was talking about it.
So what has he not done?
I just feel like he hasn't reached back out to my dad and talked about it, because my dad was telling me.
He's not required to speak with your father about everything to do with your case. Mr. Moore, you're 35 years old, right? Okay, so why does he need to speak with your father about it?
My dad, he knows a little about the law.
More so than your attorney?
Yes.
Well, then maybe he should try to get a law degree. I don't know what to tell you, Mr. Moore. I'm not trying to be flippant here, but you have a lawyer. He's tried to speak with your father, from what you both have told me.
Well, I have spoken with him.
That's what I'm saying. So what else does he have to run by your dad? Well, then if you've got something else you want to file in writing, Mr. Moore, you're free to do so. Otherwise, I'm not going through any more kind of a Nelson inquiry here, because you haven't told me anything that he's failed to do for you. Just saying, I don't think he's in my best interest is not sufficient. What would you like to do today?
Judge, let's pass it until the, date
Sixth?
was the 27th.
You want the 27th?
Yes, sir.
With or without subpoenas?
Judge, I'm gonna say without subpoenas.
You agree with that, Mr. Moore? All right, August 27th, 9 o'clock without subpoenas.
Judge, did you receive the email that was sent to your judicial assistant, Ms. Rhodes, regarding Mr. Conley's
I did.
situation? Okay.
Sure.
We are.
All right, Ms. Dudley, what do you have? Yes, sir.
This is Philip Merritt and 22 CF 2724.
All right, what are you doing, Mr. Merritt?
We don't have an offer yet from the state. It's my understanding, what I was just told when I got here, was that he's violated by saying, probation did a search, saying that there were firearms in the house. And then my understanding is they're going to charge him in a separate case with possession of the firearms, ammunition. So as of right now, we didn't have an offer on the case. I would ask for continuance to another miscellaneous date. My house told him what they told me this morning. It was a case I was going to depose on anyway, based on my understanding. A lot of it, the stuff was unlocked, was locked up. So I don't know what evidence is he actually possessed it.
But his current violation is refusing a warrantless search for the same kind of issue.
Yes, sir. It's on that. So he
So
doesn't
what would-
score DOCs. Just that issue. If that's going to up what his offer is. I think he has 20.
What would you like to set it for?
What's your next?
I've got the 6th, which is next week, and I've got the 27th.
Can we just do the 27th, Your Honor?
Got 9 o'clock without.
That way we'll know if they're going to charge him or not.
All right, August 27th, 9 o'clock, no subpoenas.
Your Honor, I had asked that Jacob Gabani be added, and we contacted your office. He wasn't on the transport list. Could we bring him at 2 o'clock so we can at least have that hearing?
I thought I said we could bring him, but I guess
He
it
was-
didn't
yeah,
get
yeah.
transported.
Yes, sir. Can we bring him at the 2 o'clock, on the 2 o'clock docket? I'll come back over.
What was that for again?
That's a motion for furlough, Your Honor.
Furlough, that's right.
All right, Your Honor, I will be back at 2 o'clock.
All right, thank you.
Thank you.
Does anybody know anything about Jason Cobb with Justina Eastley?
Has she been transported?
No.
You know, with the court's permission, I'm gonna duck out and get some.
He's supposed to be here at 2 o'clock, so let's just bring her at 2. Maybe he thought all his cases were at 2.
Probably thought it was over.
He's got Ford and Brian this afternoon.
And then same question with James Owens and Jace Beck.
No.
Beck in jail here? Is Beck in custody here?
He